Okay, I see it's 1 minute past 10. We know it's a Friday, so a lot of people might still be busy and still have some work to do. So good morning, ladies and gentlemen, and welcome to our inaugural Nova Labour Law Chambers session, the first of a series of webinars that we will be presenting throughout the course of the year, dealing with current labour law topics. My name is Vaughan Botha, and with me is Jacqueline Ezel, dialing in from our Cape Town offices, who will be presenting today's session. Our content was initially planned around mediation and the importance of counseling today, but due to popular demand, we have decided to start with harassment, considering the recently promulgated Code of Good Practice. And we are hopeful that our insights and experiences that we will be sharing would be impactful to your business. We will provide for an opportunity for questions afterwards. You will notice that we have scheduled the webinar for 1 hour and 15 minutes, and our intentions are to allow for that extra 15 minutes of questions. So please don't hesitate to engage with us. This is very much a discussion forum, and we welcome your comments. Also, please note that we have a questions and answers functionality on the webinar, and we will be manning that throughout the course of this session. Without further ado, Jacqueline, over to you.
Good morning, everybody. My name is Jacqueline, and it is my pleasure to talk to you this morning about the topic of bullying and harassment. And the reason why we are now referring not only to sexual harassment anymore is because we do have a new code that we now have to consider. During the course of my presentation this morning, I intend to cover the following topics: the purpose of the code, how to apply the code, what would constitute harassment, procedural obligations of employees. We'll take a look at the difference between what we previously had only sexual harassment, whereas now we deal with bullying and harassment as well. I will also touch on a couple of cases just to make things a bit more practical. But I might be moving around between the topics, but the intention is to give you an overview of the most important aspects that we should take note of and what we should possibly implement in our workplaces. Although we talk about workplace harassment, you will see then when we start discussing the different aspects, the obligation of the employer is not limited to only the workplace. There are a few other, for example, service providers or scenarios or workplace settings or work-related settings where the topic is also very much relevant. Up to the 18th of March this year, we only dealt with the topic of sexual harassment as codified. And we had two codes, the 1998 Code of Good Practice on the handling of sexual harassment cases in the workplace. And then in 2005, a number of amendments was made to the code. But the 2005 code did not repeal the 1998 code. So then according to section 203, subsection 3 of the Labour Relations Act, for example, in some of our arbitration awards, we would see that commissioners reference both codes. Up until the 18th of March this year, this was the situation. I would like to use an example at this point already, the impact of the code. Previously, sexual harassment, we know what it is. We've all seen different examples, have heard of different examples, but what is now the difference? Earlier in the year, a client contacted us and said there was an incident in the workplace where an employee came to human resources and said, we work in these teams and there are 5 colleagues, and repeatedly when they walk past my workstation, they will poke me in my ribs. And it's like it's sort of a joke, but you know, it's come to a point where I don't like it. It just makes me feel not nice. I want it to stop. So the employee said she told the 5 employees they must please stop doing this. 3 of the 5 did stop their conduct, but 2 continued. So the employee got to a point where she then approached human resources and said, I don't necessarily want anybody to get into trouble, but I want it to stop. So at the time, what label would you put on the conduct where it's like a joke, but I keep poking you in the ribs. You don't like it. You tell me I must stop. I ignore you. We didn't really have a name for it. So at the time, we just had recorded discussions with the two employees. We were happy that they did realize that their conduct is unpleasant. It makes this particular employee feel awful. It's just not nice for her, and it did stop. Whereas now, if the incident happened after the 18th of March, 2022, that is typically something that could possibly constitute workplace bullying because it went on and on and on. Not necessarily sexual in nature, but it wasn't pleasant. It created an unpleasant working environment for the employee. So the net is now cast much, much wider when we look at conduct in the workplace that is unacceptable. So previously, pre-18 March 2022, sexual harassment was codified in the two different codes, 1998 and the 2005 code, whereas now we've cast the net much wider: harassment in general, violence, victimization, and bullying. So previously, most disciplinary codes, or even now, have specific charges for violence or verbal threats or physical threats of violence, but it's also now codified, which places almost a bigger onus on the employer to make sure that the workplace is safe. You will note that I will refer a number of times to the employer's obligation to create a safe workplace. What is easier now, we only work with a new code, and the 1998 code and the 2005 code are no longer relevant for us. However, if we do look at case law, we will still find references to the previous codes, and in that sense, the case law that we have remains relevant on the particular topics. The purpose of the harassment code. There's a global focus on eliminating the unwanted conduct that is described in this code in the workplace. And I'm sure you'll all agree with me that before COVID and after COVID, the world has become even smaller. People work more remotely, more globally, across continents. So South Africa needs to be aligned with what the world trends are. So we want to comply with international obligations to prevent and eliminate all forms of harassment in the workplace. So the code is helpful for us to see what do we currently have in the workplace, what policies do we have, what procedures do we have, and to use the code as a guideline. What Nova has done so far for some of our clients, we don't reinvent the entire wheel. We look at, do you have a sexual harassment code? How do we cast that code wider to now align with a broader description of unwanted conduct? Secondly, disciplinary codes. Usually companies' codes already provide for sexual harassment as a transgression. Now one will just cast the net a bit wider and perhaps add a few other descriptions. But it is important to make sure that these policies and documents and procedures are updated to be aligned with what is now the law. Interestingly enough, also, it's not a choice. It's not the employer's choice, it's an obligation. So it has to be done. The application of the code is where I'd like to refer back to what I said at the onset. Yes, we talk about the workplace, but the workplace is not always just physically the building where people used to come to work from 8 to 5. We talk about employers, employees, applicants, owners, clients, customers, people that come in and out of our businesses, or you might have a service provider providing transport to your staff. That official company transport also creates a space that this code will apply to. We can have volunteers coming into our businesses. We might have an official golf day. It's a work function. The code will apply. We might go to trade fairs or team building events, and the code will apply. So you should not think in terms of an office building and only the employees that come there is subject to the code. anyone coming in and out of our work environment, be it at a team building, a fundraiser, a conference, the scope is wide. So I think it creates a situation where we all need to be very mindful of how we conduct ourselves and are we being professional. A little bit later on in my discussion, I will give a few examples of how the courts have described conduct and even commissioners, how they've described what employees should and preferably not be doing at work. So be mindful that the scope of the code is wide. Don't just think in terms of employee, employer, and workplace as in the office. It's much broader than that. All right. In law, we usually talk about substantive fairness, procedural fairness, or the code provides substantive clarity on what is harassment. When is something harassment? When do you put that label on to say this is now harassment or this is bullying? You will see that I have put some of the key words in bold that will be our pointers. Unwanted conduct, which impairs the dignity, or it creates a hostile or an intimidating work environment for one or more employees. It's calculated. So I intend to work with a plan to bully you or to push you or to make you feel bad progressively. And the reason why I use the word progressively, when we deal with harassment, victimization, bullying, sexual harassment, usually it is not a once-off incident. It progresses over time and it is repetitive. But when we talk about sexual harassment specifically, a once-off incident of a sexual assault can meet the requirements of sexual harassment. But in general, it's a progressive, calculated, I keep doing it, I keep going at you, I keep making these comments, I keep behaving in a particular manner. And that is then when it constitutes harassment. So there's different forms of conduct that is very easy to identify. I call you names. You can hear it, I can hear it, people around us can hear it. But then there's more subtle ways of harassing and bullying people with negative gossip, spreading of rumors, cyberbullying, emails, WhatsApp messages. So there are very subtle ways also of creating this hostile working environment. I cannot stress enough that these situations, there isn't a one-size-fits-all little checkbox where we tick, 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 and there we go. Really, if ever there was a time where you need to look at a situation case by case, it is when we need to apply this code. No two situations are the same. Circumstances differ. People's experience differ. So it is very important when you deal with these situations that you make sure that you use credible service providers if they assist you with dealing with your IR and ER matters. Like I've already said, procedurally, the code makes it clear. Employers don't have a choice. Employers must take proactive remedial steps to prevent all forms of harassment in the workplace. And that's a mammoth task. It's not easy, but to motivate you to make sure that you make an effort with this, if we look at the Media 24 case, which is a fairly old case, it's a 2004 case, the employee reported sexual harassment and the manager failed to do anything about it. The situation became progressively worse. And not to make this a case law lecture, the long and the short of the matter is the court found that the employer did not protect the employee, did not create a safe working environment. And note, 2004, it's almost 20 years ago, the court awarded 750,000 Rand for loss of income and medical expenses. That is one of the biggest settlements or awards that we've had at the time. In America, these amounts is small change, but for South Africa, that was a very big award. So there's a real risk for the employer in not making sure that they put the right things in place and apply it consistently. Another word that I use so often when I consult with clients is consistency. Consistency. It's tiring, but it's a must. At CCMA, some of the biggest pitfalls for employers are inconsistency. So again, update your codes, update your policies, make employees aware of it, implement it. Right. So procedurally, it's a must. We must take these steps. So in some instances, we have smaller organizations. They don't have vast number of policies and procedures and documents. If it is at all possible, have a sexual harassment policy, because that policy will be the go-to tool for the employee to know, if I feel I'm being harassed, if I feel I'm experiencing intimidating behavior towards me, let me look at the code. Let me look at our policy in the workplace. What is the description? What are the steps that I need to follow? Routinely, when I discuss contracts with employees or new policies is being put in place, and we talk about harassment, there's two things. I say to the employee, the employer must protect you, but if you do not report it, the employer cannot help you. So make the tool available to the employee so that the employee knows, this is what I should do. This is where I should go and to whom I should go when I possibly experience a situation that constitutes harassment, victimization, bullying, or sexual harassment. So you must communicate your policy to the staff. The policy must be clear. It needn't be a technical, legal document that hardly anybody can understand. That is not going to help your staff, and it will also not tick the box for you having met the obligation. It must be an understandable, user-friendly tool. Your layer of management that needs to deal with a situation once it has been reported also needs to know what is expected of them and how it should be handled. So the ideal is to update your policies and procedures, have a proper training session, roll it out, and make sure that everybody understands what is expected of them and what are the steps to follow. An interesting scenario for me is always when I look at these policies and procedures, and there's an informal process and a formal process, and then we also have possible disciplinary action. I'm not a big fan of informal processes because in the day and age that we live in, unless something is documented, it's very hard to prove that it has taken place. So for me, I prefer a documented process, which means it's a more formal approach. That is the safe approach. It safeguards the employer and it also safeguards the employee. And then we also have disciplinary action. So if there is a formal discussion or a formal investigation into an incident, it could transpire that disciplinary action is required if the incident does constitute a form of victimization, bullying, harassment, or sexual harassment. If the formal investigation shows that this incident does not meet the requirements, then obviously you will not follow disciplinary action. It's very useful to make sure that you include your policies and procedures in your orientation or in your induction. When you take somebody new on board, make sure that this policy, your harassment policy, and the steps to follow is communicated at the onset of the employment process. You'll see big in bold confidentiality. Confidentiality is a requirement when we deal with these forms of conduct. Previously, we only specifically had the codified information surrounding sexual harassment, but now we also have the other forms. The long and the short is, if you're going to have an investigation, in all likelihood, more than one person might be involved. There might have been a witness who saw something or heard something, or if you're going to go down the disciplinary route, you might have testimony of a witness. It's not going to take place in a little capsule, in a little vacuum, but it is very important that people know whether you're a witness, whether you are the alleged perpetrator or the possible victim. You cannot talk about this on social media and identify the people that are involved. You cannot discuss this on your smoke break or in the canteen. It is confidential, and we need to protect the identity of parties involved. Why do I say parties involved? There might be an allegation against a particular individual, and it is found that the allegation is not true. It can be very damaging to an employee's career when they have been accused of sexual harassment and then it's not the truth. So that is not something that you don't want to be called an harasser or a victimizer if that is not the truth. So until the situation is contained and thereafter, confidentiality is very important. Okay. What constitutes sexual harassment? It can be sexual advances. It can be a request for sexual favors. It can be remarks, gestures, physical contact, a wolf whistle, just sending around images that is unacceptable or explicit. You can constantly send somebody suggestive messages or emails. Sexual harassment is fairly easy for us to identify. It's a body of law that's well developed. There's a lot of case law. So it's not a struggle for us to identify what it is. I would just like to share a couple of examples with you on this topic. We had a situation with a client of ours a couple of years ago, senior manager, factory environment where females are in the minority, more male-dominated environment, forklift, storeroom, factory, and there's like a neutral gender cloakroom, toilet. So one of the females wanted to go to the toilet, and they found that when you go into this little area, there's basically just a door with the basin and then the toilet, and they would like to be able to lock this outside door. So she raised it with the manager, and he said, why do you want a key? I actually want to come to the toilet with you. It went in passing. Then one of the contractors came to site, and they routinely had this arrangement when the contractor comes to site, petty cash will be given to this contractor. He'll go out, he'll buy a couple of things. They have eats and treats. And when he handed back the change to the female employee, the manager said, that's for services rendered. Okay. And so it went on. One of the colleagues went on maternity leave, and in the morning meeting, a couple of months later, they then shared the baby was born. And then the manager said to this female employee there in the group, let's go make a baby. And eventually, it escalated to the point where he even tried to hug the female employee. He was dismissed, and that dismissal was upheld at the CCMA. There's just conduct that is completely unacceptable in the workplace, and some employees knows the boundaries and they don't adhere to them, and others know the boundaries, and once they've been reprimanded, if they stepped out of line, they'll back down. Schedule 8 of the Labour Relations Act does provide for dismissal for a first offence of sexual harassment, but it's not to say that it should always be the case. There's a lot of factors that will come into play to decide what would the appropriate sanction be. So in a nutshell, sexual harassment, we've been dealing with it for a long time. Also, although often we find it in situations where there's a more senior employee managing a more junior employee, it's not to say. It can be male, female, 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 junior, senior, contractor, employee, colleagues. There's no specific set of facts where it will always be a male manager harassing a junior female employee. We are long past that. It can take any of the various combinations. If we look at harassment and bullying, unwelcome conduct, like I said, it creates a hostile working environment, or it makes a person feel intimidated. It can be verbal, it can be physical, it can be threats, it can be emotional abuse. Like I've already highlighted, it's usually repeated conduct that creates a buildup. One of the aspects that my specialist witness testified about, the psychologist that I used in the sexual harassment arbitration, she specifically referred to research where they have found that the psychological impact of an ongoing harassment is far worse sexually. If we talk about sexual harassment, ongoing sexual harassment is far worse psychologically than a once-off sexual assault. That was I had to think about it long and hard. It's evidenced in research, but for me, it was very hard to accept that. But it just shows us the toll that this ongoing onslaught, little by little, every day, not knowing when I go to work tomorrow, what's this person going to do to me next? You know, I don't want to go to work anymore. I avoid the canteen because I'm scared I'm going to bump into this person and I'm going to hear these comments. So the emotional toll and the psychological toll of harassment and bullying and victimization, we should not underestimate it. It is massive and it is ongoing. I'd also refer just to some notes I've made. Global anti-sexual harassment movement have also published data where they stated that in most instances, the trauma of the victim persists long after the incident or the incident has stopped. So it's an ongoing invasion of that person's privacy and mind and emotional well-being. And then also, in the same data, it was pointed out that the reason why people sometimes take very long before they report it is, for example, they feel paralyzed, they're frozen, or they're confused. First, they believe, oh, but this will pass, or they start blaming themselves. Two of the victims in my sexual harassment arbitration, both of them told me, you know, we started thinking, but are we doing something wrong? You know, should we be in this job? Isn't it perhaps rather environment just for males? Should we rather not be here? And that is exactly what this code wants to do. The code wants to create equality in the workplace. It wants to create a situation where everybody can work in any environment free of fear of I'm a male or I'm a female or I'm from this culture or I'm from this religion. It needs to be, the workplace needs to be a place where everybody could come and just contribute their skill, because that is why we are there. So I've also bolded the part about condescending eye contact. I think initially when the code came out, you know, people talk and they say, listen, but am I going to be charged with victimization or harassment the first time, or if I just rolled my eyes at my supervisor? No. I used the example in training a couple of days ago where the training group consisted, for example, of 5 females. I'm also a female, and there was 1 male in the group. And I used the example to say, if this group is a group that has a weekly or a daily meeting, and every time when this meeting takes place, everybody has a turn to say something, but the manager or another female in the group, every time the male speaks, she starts tapping her fingers and rolling her eyes and frowning and sighing. And this happens every morning or every week. Yes, then this eye contact, or the tapping of the fingers, or the frown, or the sigh, or the distaste in the body language, then that can become bullying or victimization, because I do this only when the male colleague speaks, and I've been doing it for a couple of weeks, and there's no ground for me to be irritated or rolling my eyes or showing this impatience or distaste towards this male colleague. So that's an example. If my supervisor comes past and he says, listen, put your phone down, and I sigh and I roll my eyes, I didn't then bully my supervisor or victimize my supervisor because I rolled my eyes at him or her once. So I'll talk a little bit about the test. The test in law is the reasonable person test. In most areas of the law, the reasonable doctor. So the standard that we would use to determine if a doctor was negligent is we will look at what do we expect of the reasonable doctor or the reasonable architect. Would the reasonable architect have designed the bridge so poorly? No. So when we look at harassment, victimization, bullying, and sexual harassment, it's very important. There's an emphasis on not what the perpetrator intended, but it is how the victim experienced the conduct. That is one very important aspect. Often in these cases, the perpetrator would say, but you know what, I actually didn't mean anything by it. You know, I didn't really mean I'm going to push you in a corner and shove my hand up your skirt. You know, it was a joke. I didn't mean it. But it's about how the victim perceived it. But there's a little but, a test. How this victim perceived it. Is this how the reasonable human being would have experienced it? So say, for example, somebody rolled their eyes at you once. Now you're feeling victimized. I think it's safe to say that the reasonable person will say, listen, yes, it might not have been nice, but one rolling of the eyes, that's not victimization. I often find also in hearings, for example, for late coming or absence, the person has got a very bad track record. They're constantly late, or they take extended breaks, don't return from lunch, things like that. And then obviously the manager manages the process and addresses the conduct progressively. Then suddenly in the hearing, the employee would tell me, no, but my supervisor is victimizing me because he's reprimanding me all the time. He's reprimanding you all the time because you're late all the time. He's not victimizing you. He's applying the workplace rules consistently. So victimization is also not like a little safety jacket that you can put on and it's going to protect you when you've misconducted yourself in other areas in the workplace. It's not like a little magic button that you press and then suddenly you're saved. So there's a lot of factors to consider when we talk about this topic. So the reasonable person test will also apply. So yes, it's the view of the victim, how the victim perceived it, but we need to balance it with what would the reasonable person in the context have experienced. Okay, so we have touched on a little bit.
Jacqueline?
Yes, Vaughan.
Just want to share some interesting feedback. So we've launched our poll, and it's quite interesting to see that 67% of the viewers have voted for yes, that their harassment risks are fully contained. That leaves us with about 33% that feel that it doesn't. And that is quite reassuring. And especially as you said, with sexual harassment having been something that we've actively managed in the workplace, it shows that the majority of companies are quite mature when it comes to this type of heinous misconduct. I just want to share something, on my side, something that I've experienced as well. You were speaking about that intentional conduct, on the employee, and I do think that as company owners and as HR professionals, we are constantly bombarded by all these regulations in trying to comply with the law and managing that risk. And at times it might feel that it's just too much and it's almost unmanageable. But something that I've consistently seen in the cases that I've presided over with especially containing sexual harassment connotations, is that a lack of remorse on the alleged employee side, which was always very interesting to me, because as you speak about that reasonable person test, if somebody accuses you of something that you've done and you haven't meant it, your natural response would be a matter of concern, and that you would want to rectify it. That old saying of good faith towards your employer. And consistently, we've seen that once the investigations have been concluded and the employer has solid evidence, that there's an absolute lack of remorse, which for the HR professionals on this call, I always think that that's a tell sign to know that whether you're on the right track or not. And then when we come to that confidentiality aspect, something that I also want to note is that we often see how disciplinary matters are, or the risks related to it are exacerbated by failing to contain that confidentiality. And I do believe that speedy resolution is at the heart of containing this risk. And that's where your policy becomes so important. It essentially becomes that catching net and that safety net for your managers to number one, identify it. And once they've identified, to act. Because very often we think that we've contained the risk, but with the nature of sexual harassment and harassment being such a personal thing, we often find that the employees wouldn't report it, and then only afterwards employers would realize that the problem was bigger than they had anticipated. So that policy, very important, the confidentiality, and for the specialist on this call, look for that sense of remorse, because if it's not there, you are most likely on the right track. Just wanted to share that with you. Thank you. You can continue.
Yes, no, thank you very much, Vaughan. That is very important. And I think if I can refer back again to the arbitration we did, the senior manager was constantly trying to make his conduct as if it was like, in fact, his advocate said, it's actually just like a blink of the eye, it was like jokingly. So in that case as well, there was absolutely no understanding of, or a want to understand what he has done to these victims of his. So yes, remorse is a very good indicator also of, is this person open to changing their behavior? Because ideally, discipline is supposed to be progressive in nature. So if there is enough indication that the person is remorseful and hopefully will change their behavior, and it wasn't of such a aggravated nature that it poses an ongoing massive risk in the workplace in general, then obviously one would look at sanctions short of dismissal. And I highlight them here under formal process disciplinary steps. A situation where somebody's been found guilty of this type of conduct doesn't necessarily have to result in a dismissal. There are other options to explore depending on the situation and on the nature of what has taken place. Obviously, these things vary in intensity and the impact on the victim and in the workplace in general. So sometimes a warning is sufficient, sometimes moving the person to another area. Demoting is also a form of punishment, or then obviously dismissal. In certain instances, the victim can always decide to lay a criminal charge, but that is something separate from the workplace. The employer cannot do that on behalf of an employee. The employee, him or herself, will have to decide, depending on the situation, what they want to do. Okay. Let me just move on. All right, so if we look at a couple of cases, I've already referenced the Media 24 case, where the employer failed to create a safe working environment, failed to protect the employee. And what I found very interesting, although this was a 2004 case, already at the time, the judge was very forward thinking and used the term psychological injury, whereas now in the code that has been gazetted now, we see a lot more focus on the psychological injury, the emotional impact. So the judge in the Media 24 case was actually very forward thinking in how the impact on this employee was described and assessed. All right. One of the cases that stands out for me, and I think also because, let me put it this way, I appreciate the fact that our judges and commissioners don't mince their words. They come out very strongly about this topic because it is a very serious situation in the workplace. Up to now, we've had a lot of case law only on sexual harassment. Going forward, we'll start seeing cases that deals more with the bullying, the harassment, and the victimization as a new topic now since the new code has been enacted. But what we have for now to reflect on, I can share with you. In this case, the judge said sexual harassment is demonstrative of skewed power relations manifested in forms of oppression, victimization, and intimidation. So here as well, you can see all this, although this case was 2016, it wasn't a case under the new code. Already there is made mention of just plain victimization, intimidation, oppression, and that has now been pulled through into this new code. And I think that's one of the very exciting parts of working in this field. It's a very progressive field where things develop a lot. We've got one of the most advanced constitutions in the world, and the Constitution is basically where a lot of our other legislation stems from, like, for example, the Employment Equity Act. And then again, the Employment Equity Act gives rise to a code like what we're talking about now. So all of these things are interlinked, and over time, these things develop. So in 2016, there was just mention of victimization, intimidation as part of the sexual harassment case. And now we have a code that actually focuses on some of these other types of conduct as a specific transgression as well. Also, this quote to me is very important. It again highlights how the courts view this type of conduct. Sexual harassment is the most heinous misconduct that plagues a workplace. Not only is it demeaning to the victim, it undermines the dignity, integrity, and self-worth of the employee harassed. The harshness of the wrong is compounded when the victim suffers it at the hands of his or her superior. And so it carries on. So again, it brings me to a case that I want to share. It's the Rustenburg Platinum Mines case from also 2016. Here, what was very interesting to me, and it ties in with the power imbalance that sometimes accompanies this type of conduct. This employee, female employee in the mine, suffered sexual harassment for 8 years before she spoke up, due to a number of reasons. The harasser's wife also worked at the mine, and she didn't want to cause an upset. It was one of the things that was explicitly stated in the court case, because obviously you would want to know, why do you wait so long? And she was able to explain why she couldn't get herself to speak up about the situation. So it brings me to another aspect that has been highlighted in a hearing that I dealt with, where the perpetrator said, but why did it take her 3 months to actually come to HR? You know, if it was so bad, why didn't you go to HR immediately? And like I've already indicated to you, what we found in the global anti-sexual harassment movements, the trauma, the realization of what you've actually experienced sometimes take a little while to set in, and before you can pluck up the courage to actually go and talk about it. So what we also see in the court cases is there's a difference between 8 years ongoing sexual harassment and speaking up versus an incident, and then it takes you 2 years to go and report it. The court will probably not entertain the situation if you've waited 2 years. But if the harassment or the victimization spanned over a period of 2 years, and you then took, for example, after the last instance, 2 or 3 months to actually pluck up the courage to speak up, that will not count against the victim. False accusations. I cannot stress this enough. The examples that we have to date relate more to false accusations of racism or the use of derogatory language. But the same applies when it comes to harassment, victimization, bullying. If you falsely accuse someone, it is just as worthy of a dismissal as an actual act of victimization or bullying or harassment. I cannot stress this enough. Employees must realize it is a very, very serious accusation to make, and it can be very damaging to the reputation of an employee if you falsely accuse him or her. That is also, once again, why the confidentiality is very important. But people must be very careful to just in passing say, and I can use an example here. In the call center industry, call listening is an integral part of how they quality check what agents do on the recorded lines. So there was a situation where there was a change in the commission structure, and the particular employee had to reach a certain KPI before they could qualify for a commission, and he was then unhappy about the change in the commission structure. And the manager wanted to now investigate the issue that he raised. He raised a formal grievance. So as part of her investigation, she also wanted to listen to some of his calls, and she did some call listening. And in the facilitation of the grievance, he then actually on paper accused this manager of victimizing him because she's doing call listening. That is a blatantly false accusation. He raised the grievance. She was supposed to investigate it. And on the whole, in the call center industry, call listening happens on a daily basis. So I cautioned the employee and I said to him, going forward, you should be very, very careful to just make random accusations. Think about what you're saying and think about the impact, because there's two sides of a coin. And he just looked at me with like big eyes. And I said, heed the warning, think twice. So it is very serious. And similarly, when a case or an accusation is raised with the employer, they must investigate it to ensure that they keep the workplace safe. Similarly, if it's a false accusation, you cannot just leave it at that. It's misconduct to falsely accuse someone of harassment, sexual harassment, bullying, and victimization. It's what they call in Afrikaans, 'n tweesnydende swaard. It cuts both ways. So you cannot only prosecute actual perpetrators, but the false accusers go around calling people victimizers, calling people bullies, and nothing happens to them. It's 'n tweesnydende swaard. Okay, so this is just a short summary of the sources that I have used. Like I said, there's a lot of case law that we have that pertains mostly to sexual harassment up to this point. But like I've illustrated, you can clearly see how the undertones came through as early as 2004, 2016 to where we are now. I hope that this has shed some light for you on to just check what you have. It sounds to me that a lot of the participants on the call feel that they are in a good space. If you feel you've got a little bit of work to do, then I hope this was helpful for you to know which direction to next. So thank you very much, Ron.
Excellent. Jacqueline, thank you very much for that insightful information that you shared with us. It's such a big topic, and especially after the Nell versus Transnet case, I'm sure it's going to be a developing topic as we go. So thank you very much for your research and your inputs in that regard. Just for the rest of the participants, this is the opportune time for you to ask any questions whilst I close off. So please feel free to raise your hand or to ask any questions, and we'll kindly address those whilst we have a little bit of time left. But just something that I want to close off on my side, we always speak about knowledge being powerful. And very often we find managers and supervisors not being equipped with the necessary knowledge and skills, or tools to be dealing with these type of things. And then what happens is they tend to either bury it or deny it. And that's probably one of the most drastic responses that we can find in these type of misconduct cases. And similar to what we find when we do our labor law training with managers, there's a sense of equipping them with these tools in order to do this very, very tough job, which is managing people and not machines by itself. So thank you very much for that today. I see we do have a few questions here. I just want to see. Just want to check on the questions answerable. Is it possible to share the link or the codes? So those codes are available freely on the internet. So if you Google it, just the code of good practice on the harassment, you will openly find that. So that will not be a problem. And will the presentation be made available for training purposes? And so we have recorded this session, and this session will be made available afterwards. And if you would like any additional training in this regard or detailed training in this regard, please reach out to us. Very much your policy on harassment is going to be important in terms of dealing with it. There's also a question in terms of the Nell versus Transnet case. That's a recent case. You would have seen recent publications by the well-esteemed Cliff Decker team, where it was a situation of derogative comments being made in an enclosed room, and that employee was dismissed, and he was essentially reinstated after that arbitration process. We are yet to see what the labor courts and labor appeal courts are going to say about that, but we definitely support the notion that that type of misconduct doesn't have a place in the workplace. And as Jacqueline mentioned in the first part of her presentation, that consistency is key. If we're going to allow that type of conduct behind closed doors, you can just imagine what a wealth of problems that's going to open up for employers and for employees in the workplace. We come on the backdrop of 2 very tough years with COVID, and especially with emotional wellness that we've seen being a highly problematic item in the workplace, something we're also going to be discussing next month. And to have harassment in the workplace would certainly exacerbate that problem for employers. And with respect, employers are on a mission to steer the ship after the COVID and to get their businesses running again. This is not the type of conduct that is conducive to running an effective business. There's another question. What right does a manager have in a business if they are falsely accused and where the business does not address the employee who has made the false accusation? This is very much in line with Jacqueline's closing slides where she spoke about those false accusations. This is based on the assumption that an investigation has occurred into the manager's conduct and where the manager is found to be at no fault. So the question is, what can the manager do? And the question is, lodge a grievance, ? And I can only assume that the manager should also have access to a safe workplace. Absolutely 100% correct. And it was a very purposeful insertion of Jacqueline's slide on the false accusations. Because as I said, knowledge is power. And what we don't want our managers to do is to feel that they don't have controls to manage their respective departments. It's absolutely not a free for all to make allegations and to think that there's not going to be repercussions on that. Jacqueline, do you maybe want to add a comment to that?
Yes, indeed, Vaughan. I think as a manager, it would then be sad to have to lodge a grievance, but if that is the platform to raise the concern, then I usually say to any staff member, use the tools that is in the workplace. So if your tool is to use the grievance platform, then yes, absolutely. I'm not supportive of ever running to a bargaining council or a CCMA unless you've exhausted your internal processes. I think here the employer must also just remember that if they ignore this employee that's falsely being accused and they don't pay attention to, like I said, the flip side of the coin, it could also result in a situation, I'm speculating if it carries on and on, where it becomes a matter of a constructive dismissal. And if we look at what we've seen in the Media 24 case, that can have massive repercussions, because if somebody is falsely being accused of being an harasser or someone is a bully, it impacts your reputation. If you work in a larger organization, and that is the type of rumors that is spread about you, it can be very damaging to your career. And if we look at Media 24, loss of income, and medical expenses. 750,000 Rand 20 years ago. If I am an employer, I would take a long, hard look if my employee says, listen, I'm being falsely accused. We know it's false and you're not doing anything to protect me. Then that's a dangerous slippery slope.
Excellent. Got another question here from Monica. She says, in the mining industry specifically, we had an incident where a sexual harassment was reported only to find out at the onset that the alleged victim agreed or consented to the actions. As the matter came to the light, the alleged victim could choose to accuse the so-called perpetrator. And how do we effectively deal with the he said, she said? Thank you. So I just want to comment on it. Any unwanted conduct in the workplace or any unprofessional conduct in the workplace is a misconduct offense. That is both for the perpetrator, or it applies to the perpetrator as well, even if there was consent. The workplace is a professional place. It's subject to the company's policies and procedures, which requires professional conduct. And I do believe that any code of conduct and policy would specifically address either consenting or unconsenting unwanted conduct. Anything you want to add to that one, Jacqueline?
Yes, Vaughan, I'd like to. Yes, I would like.
You back? Yes.
Yes, Vaughan, from the Rustenburg Platinum Mines case, the judge said as follows: employees are not incapable of controlling those urges in the workplace. A workplace should be free from amorous and testosterone-filled employees looking for love and gratification at every available opportunity. So you are absolutely right. The type of conduct is not appropriate for the workplace, be it consensual or otherwise. It's unacceptable. And like a one-liner, the commissioner told the applicant in a recent case that we defended, do not hunt at work. And I really enjoyed that comment. So yes, do not hunt at work.
Monica, clearly a very valid question that you have there, and it's nice just to have that case law backing on it. Thanks for that, Jacqueline. We've got Rian Lombard as well. He says, if a person claims to be a victim of harassment, but is also guilty of harassing someone else, would the case be addressed separately? And how would the different cases have an effect on each other? So once again, if you misconduct yourself, you are also guilty. And the consistency element, again, applies to what Jacqueline has said. Jacqueline, before I give you an opportunity to answer that, I was recently involved in an arbitration where an employee was dismissed for insubordination. He went into a meeting. He was quite vocal towards the MD. He was eventually escorted out of the building. And during the investigation, and what was presented at the disciplinary inquiry, is a number of derogative messages that was presented to the employee. And at that point, we found that to be very, very impactful, because consistency would apply in those cases. And essentially, you have to be consistent in the treatment in the workplace. Jacqueline, if you want to add something to that.
I think with reference to the victim also being a victimizer, I think it will depend the timeline in which it was reported. Personally, I think I would definitely deal with the cases separately. So, for example, 2 separate investigations, 2 separate hearings. But yes, they will definitely have an impact on each other. And it's difficult to speculate now, if we don't know the facts, how it will impact on each other. But I think important in such a case is to make sure that the witnesses do not necessarily hear each other's versions, to keep some form of credibility. It might be necessary to use testimony in camera, which I know is more used in our courtrooms, but testimony in camera can be a very useful tool to make sure people are protected as well, and to just separate certain.
Excellent. Got another question here. How do you address a client that has harassed an employee? Must the client service manager handle this, or must HR handle this? And can HR address the client? So something that I would like to comment on here is the element of vicarious liability. And Jacqueline has already said it. It's your duty as an employer to create a safe workplace and to prevent harassment in all forms. Yes, you do not have necessarily have control over what external people might do, but in our experience, how you react to that is very important. To react to it speedily and obviously with the necessary care and attention. In terms of the commercial things, you would have your commercial SLA in place and your alternative dispute resolution processes in place, which would obviously run separately from that. But as an employer of the company, it's your duty to protect that employee and to show that you are doing something about it. Jacqueline, if there's something you want to add to that. Oops. I see Jacqueline is just having a connection issue on her side. Jacqueline, you back?
Yes, Vaughan, it freezes a little bit on your side. I'm not sure whether it's my connection or your connection.
Apologies for that. So the question was, must the client service manager handle this, or HR handle this? If I can respond to that question, it is your employee. So you would always want to take control over that situation instead of giving that over to someone else. And I do think especially in the mining environments, we often find that subcontractors work on site and that the mining HR personnel are very much involved with disciplinary matters, but that doesn't matter that they take over that process. And remember, it's always a relationship between yourself and your employee, and your contractual risk is between the two of you. So my advice in that instance would always be to take control over that or seek guidance and input from external parties wherever you need some advice or assistance. But it's very much your problem, and I would definitely not want to hand over my internal risk to somebody else. I would want to take control of it. Paulette Daniels asks, hi colleagues, how is workplace bullying proven? And considering the fine line between the manager's aggressively driving performance and management of the harasser. So how is it proven? Yes, absolutely a difficult topic. And we very much rely on the balance of probability. So remember, whenever we go into a disciplinary process, there's an element of balance of probability, which you would have to prove. And that just once again shows the importance of a proper investigation process to get the right people involved, to get the right witness statements and to investigate. And remember, that by itself already shows that you are acting against the alleged incident. As I said, as an employer, it's impossible for you to prevent everything. So what is always very important is to act swiftly and quickly in accordance with your policy, because that would be that would be evidence that you would lead later on to show that you've acted fairly and reasonably towards it. We often find that witness statements, are important. This, however, yes, this is a case where it very often takes place in confined spaces where there aren't other people involved, and that's why I said that element of remorse would very much be a telltale to know whether you are on the right track or not. Once again, you have to remember the accused is also an employee of your company and also requires fair disciplinary action. Therefore, that balance of probability and having sound evidence to support the facts is of paramount importance. I hope that answers your question, Paulette.
Vaughan, if I may just comment there as well, now that you talk about the evidence. Again, once in the Rustenburg case, it's such a powerful case. The judge also says specifically what you said now, in a lot of these cases, hard evidence is very hard to come by. So it takes us to the burden of proof for our internal hearings, which we can remember is a balance of probabilities. So it's not a beyond reasonable doubt. It's a balance of probabilities, because in these cases, a lot of the times, like you say, it's a he said, she said. There's seldom external parties, or in a lot of the cases, there aren't external evidence for us to use.
Excellent. And it's similar to what we found with COVID. When COVID hit the South African shores, we were all concerned about this very unknown illness and how do you prevent it. And what we found was proactively managing it in terms of your risk mitigations and putting those systems in place. Those are the type of elements that a judge would look at the end of the day when they preside over a case to establish whether you've done what you were supposed to do. Having a proper policy in place, training your managers, and investigating with urgency, those are critical items that you cannot miss. By doing so, you will show concern for both employee and for the accused. And as Jacqueline said, by containing that confidentiality, you prevent the issue from spreading wider to what it has to be at the end of the day. So those are the critical items we have. Werner Jordan, he says, good day all. At a social gathering, someone spoke of a colleague that was dismissed after calling her subordinates or team members at the time Meiscapi. In her defense, it was meant in a gesture of caring maternal figure or nature and a character, and not as a derogative intention. The complainants felt that they were seen the same as animals. That's quite an interesting point. And Werner, what I assume you are asking is, how do we deal with that? Sometimes employees say things that they might not necessarily mean, but I do think it goes back to that reasonable person test again. Employees owe their employers good faith, and an element of respect. And I do think that with a proper code of conduct and especially a policy in place that speaks about that impact of harassment, whether you intended or not intended, I think that is very important. We also saw that with sexual harassment, where many of the accused would retaliate to say that they didn't mean it. That's not necessarily important. It is how the victim perceives it and receives it that is important, and which is also important for those victims to vocalize it and to voice their concerns and disapproval of that. We always cautious employees in the policies only to remain silent and not to report matters or to show their displeasure with something that somebody says, which I think is important. So, Jacqueline, I don't know if you want to add something to that.
Yes, I would like to. If we look at what we are taught in the interpretation of statutes, the first port of call is, what would the language in the normal run of the mill, what would it mean? What is the normal meaning of the words? So if I refer to the example that was used now, to say to somebody, Meiscapi, I think the reasonable person would not experience that necessarily as an insult. If I tell you, man, jy gedraai jou soos 'n skaap, of jy's so dom soos 'n skaap, you're being sheepish, I think it's clear that is a different, it has a different tone to it than to say, ach, my ou skapie, So I think we can again draw from the normal legal principles plus the reasonable person. So I think in that case, if I constantly tell you, ach, my ou skapie, ach, my ou hondjie, then it can become belittling. But I think a once-off, I have my doubts if that would meet all the criteria that we spoke about this morning.
And I would like to add a case that I was involved with in a call center environment where there was a team of people gathering and meeting, and this one individual called the other employee my peach, or you are like my peach. And during testimony in chief, the employee alleged that in African language that is seen as a compliment. But what was very important during the cross-examination was, at that point, the employee that was called the peach, her response to it was very much of shock and disapproval. And many of the other people that sat in that same meeting could attest to the same. And that was very powerful. And again, what was powerful in that case was the lack of remorse and lack of trying to correct what had happened by that manager. He noted that she looked like a peach, and according to testimony in chief, there were other suggestive comments made. But neither during that session or afterwards did that accused employee go to this employee to say, I'm very sorry for what had happened. This is not what I had meant, and I would like to apologize for that. In fact, they remained silent, and throughout the course of the arbitration, even denied that they had done something wrong. Now, that lack of remorse, once again, even when we preside over disciplinary inquiries, is a critical element, because it shows you when somebody doesn't have remorse for what had happened, it's very difficult to expect that there would be any rehabilitative value in trying to discipline the employee afterwards. Just want to see if we have any other questions. That seems like the bulk of it. Ladies and gentlemen, thank you very much. This has been absolutely fantastic. It was wonderful with you connecting with us and asking these questions as well. It is quite daunting to give advice, obviously, in a short session like this. So please always reach out to us if you have pending matters, and if you need specialist legal advice, we will gladly assist. And I would like to say that our next session will be in June again, and please look out for that. We are going to be dealing with mediation principles and also the value of counseling, something that we often see employers lack or oversee, and which in our view has a great impact and great value to businesses. So please look out for that. And until next time, have a wonderful weekend. And I'm very happy that we don't have to wear masks at this point anymore. So have a wonderful weekend, everybody, and stay safe. Bye-bye.